Good afternoon and welcome back from the lunch break. Panel 3 is going to deal with a theme, mediating human rights protection, great power politics, and the United Nations. I have the honor to chair the panel, and I will introduce each speaker as they speak. I also have the honor to refer to them by their first name, simply because I can't pronounce the surname in most cases. So the first speaker will be Xavier-Jean. He is the Principal Counsel for the Office of the Public Counsel for the Defense. That's a mouthful, at the International Criminal Court. OPCD, as we call it. It's the OPCD office at the International Criminal Court. And his chosen topic is state cooperation via agreements on provisional release and acquittal are vital to uphold the Rome Statute principle of the presumption of innocence. But the problem is, how do we continue to realize that principle? Mr. Keita, please. 7 minutes.
Thank you, Mrs. And Justice Ebutinde. I know how I've seen you conducting some trials with a certain authority. I will try to remain in my 7 minutes, and if possible, I will save 1 minute and to offer to my co-panelists. Thank you, ICD, for this invitation, and thank you to all of you. It's really a pleasure and an honor to share such a conference. And it's the second time I have the opportunity to meet already Ogmundu and Mark, became friends. And it's a great pleasure for me to come back and to discover new friends. So my main point is to tell each of you that Article 66 of the Rome Statute states that everyone must be presumed innocent until proven guilty. You, Justice Ebutinde, you are presumed innocent. I am presumed innocent. So this to say that the 10th of April 2014, Belgium became the first country to sign a memorandum of understanding with the International Criminal Court, indicating a clear willingness to accept suspect and accused on provisional release. So I am using the word provisional release, but I should say release, because for me, release is like liberty, it's the rule, and detention have to be the exception. The terms indicate that they can receive detainees of the court on its territory on a temporary basis and under conditions established by the competent chamber. This effort was a long time in the making. Can you imagine, after 13 years, ICC managed to sign with a state party one agreement for provisional release? The OPCD, the office I am heading for 9 years and a half, Office of Public Counsel for the Defense, would like to encourage the work of the ICC on such framework agreements and arrangement for a release, acquittal, and sentence enforcement, which are essential for the rights declared in the Rome Statute. Article 68, of course, Article 67, the right of the accused person, and Article 55, the right of the suspect. We have to consider that, and I have said that this morning, ICC doesn't have army or police. We have to count on cooperation. So detention have to be the exception, respecting the presumption of innocence. Because at the end of a trial, somebody may be declared totally innocent. But having no country to welcome such a person, that's a shame for not all state party, but all our international community. So the Article 60 of the Rome Statute allowed a person subject to a warrant arrest to apply for a release pending the trial, and that can be granted by the chamber. If the chamber considers that the condition of Article 58, meaning the article conducting the chamber to issue an arrest warrant, are still valid or pending. So our fight is to show that if the conditions have changed, release have to be the rule, and it was not the case in ICC. It has been clearly articulated in a decision, the prosecution versus Mr. Bemba in September 2009, and I quote the chamber. Furthermore, the appellate chamber considered that in order to grant conditional release, the identification of a state willing to accept the person concerned as well as enforce related condition is necessary. Meaning, if there is no state ready to welcome a person, even if the chamber have decided that this person may enjoy a release, no release. Relevant example, for instance, Mr. Jean-Pierre Bemba in July 2008 was granted a release in August 2009, and he remained in detention. Why? No state ready to welcome him. The same for Mr. Gbagbo, the former president of Ivory Coast. He have requested several times to be released for health reason. They were all denied. All the requests were denied. Bosco Ntaganda accepted to surrender himself to the ICC and has a right. He asked for provisional release. All the requests denied. The same for Acquittal. At the end of 2012, we got in ICC the first and unique acquittal, Mr. Machiongu Jolo. The thing is, in his own trial, Machiongu Jolo was testifying as a witness, and he was denouncing his head of state, President Kabila. And when acquitted, naturally the Dutch authority, the host state for ICC, decided to move him to DRC, his country of origin. He decided to apply for asylum. And after some months of detention, but in the other detention unit, he was sent by force to DRC. The pertinent questions are the following. Maybe for economic reason or for security impact, states are not ready to face release or acquittal because cost for monitoring, and maybe the community will not accept that even if they are now clean, they consider that they are still guilty. We have, as a OPCD, have proposed several solutions. State to put in place some working groups or to mutualize their means, because some states are ready to welcome but they do not have the means to do so. So, in my opinion, ICC has, with the state, to follow this example of Belgium, unless the Rome Statute may be for several high-level provision totally in a vacuum. I give you one example. When OTP, the Office of the Prosecutor, decide because they have identified a light fish, decide that they will not prosecute this person because this person is ready to be a witness and to denounce the big fish. This person doesn't enjoy anymore the presumption of innocence. This person is called a dirty hand witness. Guess what? These dirty hand witnesses enjoy relocation, protection of state parties, while those who are still innocent in jail or facing ICC prosecution cannot enjoy any presumption of innocence. So it's really a signal to push, to invite you politicians, diplomatic NGOs, to push the state party and the international community to avoid what I call the syndrome of Arusha. In Arusha, there is a safe with some officer guarding the safe house. They are free because they have been acquitted. They cannot go back to Rwanda because their neighbors still consider that they have committed some genocide. And who is paying? You, and me. It's our international contribution to the UN. Think about it. Presumption of innocence until proven guilty. Thank you.
Yes, it does make you think, doesn't it? Because in most of our countries, we have a clause under the human rights, the Bill of Human Rights, where the right to a fair and speedy trial and the presumption of innocence are considered human rights. But really, the question is, when you are a suspect before the International Criminal Court or any other war crimes tribunal, are you really presumed innocent? I mean, the very fact that these courts are set up to try people like you, I think whittles away some of that presumption. And the question is, should there be a difference, a distinction between an ordinary citizen and a suspect before such courts in enjoying these kinds of human rights? And which state is willing to host such a suspect and risk or take on the risk of flight? What about after acquittal, when these people are acquitted? Why are so few states willing to offer asylum to these people? And why can these suspects not return home, or these acquitted people? Why can't they return to their own countries? I think this is yet another angle in this conference that is shining light on these kinds of people who, if you like, are the rejects of the international community that nobody wants to hear about. They too have human rights.